celebration of Constitution Day, which is actually tomorrow. We're getting a head start on that. In 2005, Senator Robert Byrd of West Virginia attached an amendment to an appropriations bill. And that amendment required that on September 17th, the date the Constitution was ratified, that federal employees should receive, quote, educational training materials about the Constitution. But it also required that every school receiving federal funds, from kindergarten through medical school or law school or whatever, had to provide some sort of programming on Constitution Day. It always struck me as a strange sort of sequence of events. In general, I prefer to take my constitutional instruction from somebody who did not belong to the Ku Klux Klan for many years. But whatever the provenance of the holiday, the American Constitution certainly is a document worth celebrating. The great British statesman William Gladstone described the American Constitution as, quote, the most wonderful work ever struck off at a given time by the brain and purpose of man. Our Constitution is more than 200 years old. It's the oldest written Constitution still in effect. And yet today, looking back, it's difficult to read the Constitution without being struck by the extent to which it really is an 18th century document. And yet, for all its 18th century characteristics, it remains functioning and relevant. It's been amended only infrequently, 27 times in more than 200 years. The first 10 amendments were adopted at the time of the Constitution, and 3 more were adopted after the Civil War. So that's about half in 2 bunches. One reason for the Constitution's longevity is that the Constitution itself is adaptable. It provides for its own amendment, although it's not very easy to do. But more important, it's really just a statement of general principles. It's not much more than a basic outline. Had it been detailed, it could hardly have survived the stress of 2 centuries during which the United States evolved from 13 states huddled on the East Coast to a nation that spanned a continent. So even if some people object to the feds telling us when to celebrate the Constitution and how, it's still worth contemplating. And that's what we're doing today. This event is sponsored by the Provost Office, which provided a budget and staff assistance, all without which this would not be happening. And I thought, almost 10 years in, it's worth taking a moment to reflect back. Constitution Day speakers at the University of Montana have included Kermit Hall, Herman Belz, Roger Newman, Paul Finkelman, Philip Munoz, William Novak, and Kent Lash. Now, these are names that may not mean a lot to some of you, but they're major figures in constitutional history and constitutional theory. Another one of our speakers is Anthony Johnstone, who's right over there, who, when he spoke here as a Constitution Day lecturer, was a solicitor for the state of Montana, and then he now teaches at the University of Montana Law School. And tonight we have a speaker who adds luster to that already distinguished list. Melvin Urofsky is an accomplished and astonishingly prolific historian of the American Constitution. He did his BA, MA, and PhD in American history at Columbia University. He completed his PhD in 1968, and then a few years later went to law school at the University of Virginia, graduating in 1983. He's taught at Ohio State University, or as they say there, the Ohio State University, State University of New York at Albany, the T.C. Williams Law School, the University of Richmond, and he spent much of his career as a professor of history at Virginia Commonwealth University from 1974 until his retirement in 2003, and he continues there as professor of law and public policy at VCU's Center for Public Policy, an institute of which he was director from 1996 to 2004. Now he's also historian in residence at American University. He's the author and editor of 52 books on a variety of historical subjects. He's also the author of, I was going to say countless articles, actually you could count them, but it was a long list and I didn't. but he's held numerous fellowships and grants. He's written count them, three biographies of Louis Brandeis, one of which appeared in the distinguished and prestigious Library of American Biography series. He's edited 5 volumes of Brandeis's letters. He's written on Felix Frankfurter, Supreme Court and Constitutional Liberties, the Warren Court, affirmative action, legal issues related to death and dying. He's pretty much covered the waterfront. He's also the author of A March of Liberty, which is one of the most widely used and most reliable constitutional histories of the United States. It's the one that I keep over my desk in my office. And curiously enough, he also has some close ties with some of our previous lecturers. With Paul Finkelman, he's put together documents of American constitutional and legal history, and he completed Kermit Hall's last book on the New York Times versus Sullivan, a landmark decision in libel law, and as he points out, also in civil rights law. So it really is a pleasure tonight to have Professor Yourofsky at the University of Montana. Please join me in welcoming tonight. His topic is dissent and the constitutional dialogue.
It's a pleasure to be here. My son's very unhappy that I didn't bring him with me. I told him he could come next time. Let me start by reading to you a few quotes about dissent. I think it useless and undesirable as a rule to express dissent. That's Oliver Wendell Holmes, Jr. Dissents augment rather than diminish the prestige of the court when history demonstrates that one of the court's decisions has been a truly horrendous mistake. It is comforting and conducive of respect for the court to look back and realize that at least some of the justices saw the danger clearly and gave voice, often eloquent voice, to their concern. That's Antonin Scalia. Great Supreme Court dissents lie like buried ammunition for future generations to unearth when the time comes. Kathleen Sullivan, the former dean of the Stanford Law School. I shall in silence acquiesce. Dissents seldom aid in the right development or statement of the law. They often do harm. For myself, I say, lead us not into temptation. Justice Pierce Butler. The right to dissent is the only thing that makes life tolerable for a judge on an appellate court. William O. Douglas. This sampling of opinion on the value of dissent or the lack of it could have been multiplied tenfold. Even today, when 4 out of every 5 Supreme Court decisions includes one or more dissenting opinions, there is still a debate over the merit of a judge declaring that he thinks the majority of his or her colleagues misinterpreted the law. I strongly believe in dissent, and I believe it has an important role to play in our constitutional dialogue. That phrase, constitutional dialogue, includes not just debates that justices on the High Court have with one another in specific cases or over particular jurisprudential ideas, but includes discussions between and among jurists, members of Congress, the executive branch, administrative agencies, state and lower federal courts, the legal academy, and last but certainly not least, the public. In the time we have, I am afraid I will not be able to cover all these fields. For that, you'll have to wait for the book, or else invite me back for a longer period. Now, the acceptance of dissent as a legitimate part of judicial behavior is not universal. There are many democratic countries whose courts operate under the assumption, often written into law, that courts should speak with one and only one voice, and that differences of opinion within the court should never be made public. I am not suggesting that individual rights are less valued in these countries, but only that varying forms of government have different understandings of how their courts should function. American courts began by following the British practice of seriatim opinions, with each justice writing in every case. The opinion of the court, a single opinion, began under Chief Justice Oliver Ellsworth and was institutionalized under John Marshall, and it became the practice for many years. If, as Holmes would later say, the law is a prediction of what courts will do, one could now have a clearer idea of what judges had actually decided and rely on that judgment in future cases. Well into the 20th century, the High Court, in more than 9 out of 10 cases, issued a single opinion of the court. Because many of these cases had little importance to anyone beyond the litigants, the justices believed, as Louis Brandeis would later say, that it was more important to decide the question than to decide it right. Even if some justices did not agree with the result, they would go along, or if they felt they could not, would merely note a dissenting vote, but did not write an opinion explaining their disagreement. In 1925, Congress gave the court greater control over its docket. Most of the cases now involve constitutional matters or questions of statutory interpretation. It became more important not only to decide, but in these cases, to decide rightly. As judges heard more constitutional questions, they found themselves developing jurisprudential theories that carried over from one case to another. Not only did they stop acquiescing, but they also felt it important to explain why they disagreed. By the time of the constitutional crisis of the 1930s, written dissents had become more common and then proliferated in the 1940s. The constitutional dialogue since then has often appeared to be a cacophony of voices, each with a different view of what a particular clause of the Constitution means. Just as not all majority opinions are equal, neither are all dissents. As Justice Robert Jackson reminded us, the vast preponderance of dissents are soon forgotten. They play little part in the constitutional dialogue and rarely become accepted by the court at a later date. But some dissents are important, and these are the ones we're concerned with, the ones that become canonical and which have influenced the constitutional dialogue. Given the fact that only the hardest cases reach the High Court, and that in each question there are a multitude of precedents, rules, facts, and subjective considerations, it is little wonder that the 9 justices would disagree. Chief Justice Hughes expressed astonishment, quote, that in the midst of controversies on every conceivable subject, one should expect unanimity upon difficult legal questions. But for nearly 150 years, the members of the court stressed the institutional unity and often denigrated dissent. Even the great dissenters like Stephen Field, John Marshall Harlan, Holmes, and Brandeis believed that dissent should be rare and unanimity the rule. It is useful to stop for a moment and briefly look at the arguments that are made against and for dissent. Without doubt, the most frequent objection to a dissent is that it weakens the force of the decision and detracts from the court's institutional prestige. Justice Learned Hand summed up this argument when he wrote that the failure to secure unanimity, quote, is disastrous because disunity cancels the impact of monolithic solidarity on which the authority of a bench of judges so largely depends. If people come to believe that the law is uncertain, that even learned judges cannot agree on what it means, they will lose respect for both the court and the law and feel free to disregard both. In 1928, Charles Evans Hughes, who had been an associate justice and in a few years would be named Chief Justice, found this argument unconvincing. Judges, he said, are not there simply to decide cases, but to decide them as they think they should be decided. And while it may be regrettable that they cannot always agree, it is better that their independence should be maintained and recognized than that unanimity should be secured through its sacrifice. Justice Henry Brown, who served on the court from 1890 to 1906, put it more pithily when he wrote that, quote, if the authority of the court is weakened by a dissent, it is probably because it ought to be weakened. Even though experience shows that complete unanimity is a chimera, most judges acknowledge that there is pressure to achieve, as often as possible, the agreement of a majority of the members on a single rationale. Lawyers want certainty that the rule expressed in case A will apply to case B and all similar and subsequent cases. Here one has the rationale of stare decisis, the doctrine of abiding by and adhering to prior decided cases. Most judges, and especially those in lower courts, feel bound to at least start with reliance on past decisions. When the court abruptly alters course, it taxes the public faith that is essential to its authority. Thus, in a case in which he disagreed with the court's decision, Justice John Paul Stevens nonetheless felt compelled to concur in the result. Quote, "I am firmly convinced that we have a profound obligation to give recently decided cases the strongest presumption of validity. For me, the adverse consequences of adhering to an arguably erroneous precedent in this case are far less serious than the consequences of further unraveling the doctrine of stare decisis. Lawyers and most judges do not want to open for future litigation questions which a decision of a court of last resort should have settled. If dissension on a court of last resort leads to uncertainty in the law, why then do members of that tribunal file opinions accusing the majority of deciding wrongly? First of all, for practical purposes, and this is what lawyers are most concerned with, the majority opinion is the law, at least for the foreseeable future. While there are times, especially if a case has been decided by a 5-4 vote, when lawyers rightly worry that a change in personnel or some other factor might lead to a reversal, they also know that in the vast majority of cases, the majority opinion will stand, if not forever, at least for the time frame which interests their clients. After all, for all the dissents filed, only a few rise to the level of influencing the constitutional dialogue. Judges know this as well, yet they continue to file dissents for a number of reasons. I think that Chief Justice Charles Evans Hughes said it best when he wrote, "A dissent in a court of last resort is an appeal to the brooding spirit of the law, to the intelligence of a future day when a later decision may possibly correct the error into which the dissenting judge believes the court to have been betrayed. Nor is this appeal always in vain." Judges dissent for many reasons, which vary from case to case, term to term, and justice to justice. Clearly, the main reason is that they disagree with either the results or the reasoning in a specific case. Justice Scalia has written that he will dissent primarily if he considers the reasoning wrong, implying that it is possible to get a result he disagrees with, yet will concede that the majority reasoning is not wholly incorrect. There are some dissents that are more matters of pique than anything else, anger that the court is not listening to the speaker who knows that his is the right constitutional interpretation. One can point to a number of examples, but to mention only two, there's Justice James McReynolds' opinion in the Gold Clause cases. He dissented in such vitriolic terms that part of his comments did not appear in the official reports. At one point, he bitterly declared, "This is Nero at his worst. The Constitution as we know it is gone." Another such dissent is that of Justice Felix Frankfurter, resentful that the court had ignored his insistence that it should not get involved in the question of legislative reapportionment. Neither of these dissents has played a role in the dialogue, in part because of their strident tone. We may admire and be moved by eloquence, as in the Holmes opinions on free speech or Brandeis on the right of privacy. We don't respond well to petulance. Sharply worded dissents by themselves do not cause rifts. Justice Scalia wrote that, quote, "I doubt whether any two justices have dissented from one another's opinion any more regularly or any more sharply than did my former colleague, Justice William Brennan, and I. I always considered him, however, one of my best friends on the court, and I think that feeling was reciprocated," unquote. According to Chief Justice John Roberts, all the members of the court are quite sensitive to the need to avoid comments that could be taken in a personal aspersions. A justice is well aware that the person who wrote the opinion she is dissenting from today may very well be the same justice who will provide her with the fifth vote in another case tomorrow. Many considerations are present in greater or lesser degree, but at the forefront of consciousness are questions involving the solution of the case at hand. Nearly all justices have at one time or another said that when writing a majority opinion, they have little leeway because they have to present an argument that will hold the other justices in the majority. The spokesman of the court, said Robert Jackson, is cautious, timid, fearful of the vivid word, the heightened phrase. You have to make adjustments, Clarence Thomas has said, to reflect the views of the majority. And if you can't do that, then you shouldn't write the opinion. When writing the court's opinion, a justice has to be very careful not to make broad, sweeping generalizations lest he lose some votes. Brandeis said that he always had to keep in mind that he was not writing for himself, but for those who voted with him. That is why majority opinions in most cases tend to be careful and precise and dull, limited to the specific facts and not venturing into broad jurisprudential assertions. So part of the dialogue is between the justice assigned to write the majority opinion and the other members of the majority. Sometimes, even without a dissent at hand, it is impossible to keep 5 votes on board. One example is a gender discrimination case, Califano versus Goldfarb in 1977. Leon Goldfarb sued after a federal statute denied him Social Security benefits because he had not been receiving half of his support from his spouse before she died. Similarly situated widows, however, received the payments. With Justice Rehnquist in the 5-4 minority, William Brennan, as the senior justice, assigned the case to himself. In his draft circulations, Brennan tried to place gender in an equal category to race, so that any government discrimination would be tried under a strict scrutiny standard. He and 3 other members of the majority were agreeable, but not John Paul Stevens, who had been on the court only a few weeks and was unwilling to go that far. Had this case come up 10 years later, Stevens would immediately have signed on. As a result, Stevens, at that point, filed an opinion concurring in the judgment, but not in the rationale. Gender discrimination henceforth would be reviewed under an intermediate level of scrutiny, not under the same criteria that applied to race. In the wings, of course, is awaiting dissent, or at least the threat of one. Dissents keep the boys on their toes, Hugo Black used to say. And clearly, from the dissenter's point of view, the best result is that members of the majority will change their mind before the decision is handed down, even if there is no written dissent. It is not a common occurrence, but it does happen. Justice Robert Jackson once commented that I myself have changed my opinion after reading the opinions of the other members of this court, and I am as stubborn as most people. Justice Ginsburg says that about 4 times a term, an opinion starting out as a dissent is so well reasoned that it convinces enough justices to join and transform it into a majority opinion. In the Brandeis Papers, there are a number of dissents written but never delivered. In some instances, he decided to quash his opinion for strategic purposes, in that the issue did not rank as high in his priorities as did other matters. But in some, the draft dissent led the court to change its mind, not necessarily coming over fully to Brandeis's position, but modifying its ruling to meet some of his objections. An essential part of the constitutional dialogue is the response of the justice writing the opinion for the court to arguments made by a dissenter. Once the conference has voted, the justice writing for the majority strains under multiple burdens. Excuse me. On the one hand, he or she cannot stray too far from what may have been a narrow agreement as to what should be said. On the other hand, the arguments of the dissent have to be taken into account, if for no other reason, to prevent one or more members of the majority from changing their minds. Justice Ruth Bader Ginsburg has written about what she calls the in-house impact, and I quote her, "My experience teaches that there is nothing better than an impressive dissent to lead the author of the majority opinion to refine and clarify her initial circulation." An illustration. The Virginia Military Institute case, decided by the court in 1996, held that VMI's denial of admission to women violated the 14th Amendment's Equal Protection Clause. I was assigned to write the court's opinion. The final draft, released to the public, was ever so much better than my first, second, and at least a dozen more drafts, thanks to Justice Scalia's attention-grabbing dissent. Her good friend, fellow opera aficionado, and occasional nemesis, Anthony Scalia, has written in a similar vein. Though the fact never comes to public light, the first draft of the dissent often causes the majority to refine its opinion, eliminating the more vulnerable assertions and narrowing the announced legal rule. When I have been assigned the opinion for the court in a divided case, nothing gives me as much assurance that I have written well as the fact that I'm able to respond satisfactorily, at least in my judgment, to all the onslaughts of the dissents or separate concurrences. Ironic as it may seem, I think a higher percentage of the worst opinions of the court, not in result but in reasoning, are the unanimous ones. In the fall of 2009, C-SPAN aired a unique program, a series of interviews with all 9 sitting justices, as well as 2 retired members of the court. In each of the segments, the interviewers asked about dissent, and what is remarkable is how nearly all the justices saw dissent as an essential component of the decisional process. Chief Justice Roberts, for example, declared that, quote, "Dissent is a very valuable part of our process. It shows the thinking of different parts of the court. It shows that arguments have been fully considered, and it's valuable for the writer of the majority because we have a healthy degree of skepticism about what we're saying to the very end." Part of the intra-court dialogue is the threat or the actual writing of a dissent or a concurring opinion that will not fully endorse the majority's conclusion or reasoning. The mechanics of the back and forth are far more complex and sophisticated than a note saying, "I am going to dissent." Sometimes the opposing justice does not agree with all of the majority opinion. He or she may be satisfied with alterations that will not affect the major holding, but will restrict the jurisprudential rationale. The majority writer has to take into account what might be called the descent of horrible possibilities. Because the dissenter need not trim his or her views to keep others happy, Justice Douglas said, "The only soul I have to save is my own." The dissenter can argue that the majority opinion will lead to a long list of terrible consequences. In Stone v. Powell in 1976, the majority by a 6-3 vote ruled that a federal court cannot review on habeas corpus grounds a state's determination regarding the admissibility of evidence obtained through an allegedly unlawful search or seizure. Justice Brennan dissented and charged that the decision would lead to a complete gutting of federal habeas proceedings for state prisoners on nearly all constitutional claims. The groundwork is being laid today, he warned, for a drastic withdrawal of federal habeas jurisdiction, if not for all grounds of alleged unconstitutional detention. There's a danger here, however, that law enforcement officials will seize upon the dissenter's exaggerated predictions and assume that is really what the majority means. To avoid this problem, some judges, such as Potter Stewart, would concur in the result, leave the dire consequences unstated, and then emphasize the narrowness of the majority opinion. Either way, the majority writer has to be more specific to ensure that the opinion does not open a floodgate of terrible practices, or to say that it actually is not quite as narrow as the concurrence argues. Political scientists have studied what they term judicial strategy over a wide range of issues, such as which cases to accept for review, assignment of opinion, and of course dissent. Holmes and Brandeis chose when to dissent, and because they did so infrequently, their opinions received great attention. Other judges, such as Felix Frankfurter, compulsively dissented or wrote separate opinions so often that few people took interest in them. Frankfurter managed to alienate most of his colleagues by both his abrasive personality as well as endless and pedantic separate opinions. He actually wrote more concurrences than he did majority opinions during his 23 years on the court. Who is threatening is also a consideration. A Ginsburg, a Kennedy, a Scalia presents the possibility of a strong and well-reasoned opinion, a possibility that no majority opinion, the writer of a majority opinion would take lightly. Warren Burger, on the other hand, has never been considered a jurisprudential heavyweight, and a threat by him could be, and often was, dismissed with a polite, "Sorry, but no." What we can say is that all these actions are part of the dialogue that takes place among the justices in fashioning an opinion. Justices are aware that while they may hold strong views on a particular issue, if they speak for the court, they will more often than not have to tone it down somewhat in order to satisfy the other members of the majority. The dissenter, of course, does not labor under this restraint. Threatening to write separately is one thing, actually doing so is another. Of course, the minority justice or justices will write, and as noted above, a well-crafted dissent will have an impact not only on the majority opinion, but may also take its place in the ongoing constitutional dialogue. A concurrence may also have those effects. One of the greatest separate opinions in the court's history is that of Justice Brandeis in Whitney versus California in 1927, which helped shape First Amendment speech jurisprudence for decades afterwards. But concurrences as well as dissents have costs involved, even if one has the help of capable clerks. They take time and energy and may well disrupt the institutional schedule by holding up decisions. In a 5-4 case, a concurrence in the result but not the reasoning means that there is no rule with precedential value that will govern future cases or guide lower courts in this area. A concurrence may also go beyond what the author of the majority opinion states, a clear signal that the issue may not have been resolved. A good example can be found in the physician-assisted suicide cases the court decided in 1997. After the court had held that there was an individual right to refuse life-sustaining medical treatment, i.e., a right to die, advocates of physician-assisted suicide stepped up their campaign and claimed that terminally ill patients not only had a constitutional right to die on their own, but also a right to have a doctor's help in doing so. The Supreme Court, as expected, ruled that there was no constitutional right to physician-assisted suicide. Chief Justice Rehnquist, whose wife had died in 1991 after a long battle with ovarian cancer, took note of the, quote, profound and earnest debate in the states over whether to permit such activity. He concluded that our holding permits the debate to continue as it should in a democratic society, a clear invitation to the public that in this area, the popular will could create a right not found in the Constitution. Although all 9 justices agreed with Rehnquist's opinion, technically it was unanimous opinion, that no constitutional right existed. 5, a majority of the court, 5 members of the court wanted to go further. Justice O'Connor qualified her support by saying that the ruling would not prevent a physician from prescribing a pain-killing medication even if it hastened death, an acknowledgement of a practice that doctors understandably do not talk about very much. 4 other justices, Stevens, Souter, Ginsburg, and Breyer, indicated that individual cases involving terminally ill patients might be decided differently. In other words, what you had here was a majority of the court concurring in the result, but essentially telling the public this issue is not closed. It can go on, and in fact, does go on. At that time, only Oregon allowed physician-assisted suicide. Now I believe there are 2 other states that do as well. If some critics view the dissent as undermining the authority of the court or making the result less clear, there are also those who dislike the concurrence and see it as little more than an ego trip. This would be true, I think, for many of Felix Frankfurter's 132 concurrences, some of which do little more than claim that Frankfurter understood the law better than his colleagues, which is something he used to tell them in person as well. Concurrences, however, like dissents, may be a useful tool in the judicial dialogue. Sometimes a concurrence in the result but not the reasoning will serve as the basis for future changes. In Roshen versus California in 1952, Frankfurter spoke for a unanimous court in holding that the state of California had engaged in a brutal and thus illegal conduct in catching and convicting a drug dealer, including pumping his stomach, without his permission. Frankfurter's opinion strongly condemned California's action, but he based the reversal of the conviction on 14th Amendment due process grounds. Hugo Black and William O. Douglas agreed with the result, but entered concurrences stating that the result should have been on specific provisions of the 4th and 5th Amendments, positions they had held since they came on the court in the late 1930s, and which would ultimately be adopted by the Warren Court. Most often, a separate opinion is, as Walter Murphy noted, essentially an effort to resolve conflict within the court by persuading in one fashion or another other justices. If well written according to Ruth Ginsburg, it may provoke clarifications, refinements, and modifications in the court's opinion. Given this limited objective, if the majority author makes changes that are acceptable both to other members of the majority as well as to the writers of the separate opinion, then the goal has been achieved and the separate opinion is withdrawn. This seems like a high price to pay given the time and energy involved in the writing of the separate opinion and the revisions and circulations necessary to achieve consensus by the majority author. But it will seem well worth the effort if the final result not only has the support of a majority, better yet, a fuller majority. It will resolve not only questions about the case under consideration, but it will provide clear guidance for lower courts in future litigation. More attention is paid to dissents than concurrences. While lawyers and judges may understand the distinctions made in a concurrence, the general public usually does not. After all, the result is still the same. A dissent, however, says to everyone, this case is wrong. It has reached the wrong result through faulty reasoning. Judge Jesse Carter of California called the dissenting opinion a forecast of things to come. These are the great dissents, he said, the prophetic ones whose arguments eventually win out. One should note that some of the prophetic dissents took years before the courts adopted their view. Stephen Field's interpretation of the 14th Amendment's due process clause in the slaughterhouse cases took a quarter of a century before it became the majority opinion. The first Justice Harlan's dissent in the civil rights cases in Plessy v. Ferguson were not validated until the 1950s and 1960s. The free speech arguments of Holmes and Brandeis in the 1920s did not see full acceptance until 1969. Hugo Black lived not only to see his argument for the necessity of a lawyer in a criminal case win over a majority, but 2 decades later he got to write the new rule in Gideon v. Wainwright. Justice Scalia has suggested that the decisions most likely to be overruled are those decided by a 5-4 vote. One might think that in closely divided cases, the force of the dissent is nearly as great as that of the majority, and in some instances this may be true. But another reason is that ever since the 1930s, the court most of the time has been closely divided. And in these instances, the death or retirement of 1 or 2 justices can reverse the court's direction. Ever since the 1970s, there's been a conservative bloc of 3 to 4 justices and a liberal or moderate bloc of the same number with 1 or 2 justices such as Lewis Powell, Sandra Day O'Connor, and Anthony Kennedy serving as the swing votes in the middle. How the replacement of any one justice can affect this balance and suddenly convert a previous dissent into a majority can be seen in the Citizens United case. A conservative advocacy group, Citizens United, made a movie attacking Hillary Clinton, then in the running for the Democratic presidential nomination in 2008, and wanted to make it available as a video on demand within 30 days of the primary elections, and produced advertisements promoting the film. The Federal Election Commission declared that showing the film would violate a ban Congress had enacted in the McCain-Feingold Bipartisan Campaign Reform Act of 2002, the BCRA, which the court by a 5-4 vote has sustained the following year. Citizens United sued, claiming this provision violated its free speech rights. Now, the major events that transpired between the court's approval of BCRA in 2003 and its decision in Citizens United in 2010 were the death of Chief Justice Rehnquist and his replacement by John Roberts, and the retirement of Sandra Day O'Connor and her replacement by Samuel Alito. Court watchers generally see Roberts as jurisprudentially similar to the man he replaced and for whom he had once clerked, but they view Alito as far more conservative than O'Connor, who for nearly 2 decades was the swing vote in 5-4 decisions and the 5th vote in the McConnell case upholding BCRA. Justice Anthony Kennedy's opinion for the 5-member majority struck down the 30-day provision. The question then is whether the repeated dissents by Scalia, Kennedy, and Thomas over a 20-year period finally convinced a majority of the court, or whether the two newest members, ideologically aligned with them, made the difference. Certainly there's been not only an ongoing constitutional dialogue over campaign finance reform, but a political one as well. The division on the court may well mirror the political divisions outside, where the argument also implicates constitutional questions such as free speech and whether corporations have First Amendment rights. Although it is often easier to follow the dialogue within the court, the justices speak not only with each other, but with other participants in our constitutional government. And so let us take a quick look at these other members of the dialogue. Aside from constitutional interpretation, a major task of the court is statutory interpretation of the laws passed by Congress and signed by the President. Clearly, not every law requires a court hearing, and even those that may wind up in the district courts or the Court of Appeals and may not raise questions that require the Supreme Court to review it. When the court passes on legislation, two primary questions arise. The first is whether Congress has power under the Constitution to enact the statute in the first place. If Congress has exceeded the power, then the law is held unconstitutional, and the only way to override that type of decision is by the amendment process. Clearest example of this is the passage of the 16th Amendment, authorizing Congress to tax incomes, a direct response to the court ruling the income tax unconstitutional in 1895. More often, the complicated process of drafting a bill has resulted in language that is far from clear as to either meaning or application. The courts are asked to determine exactly what Congress meant. By the way, I should note that sometimes this is deliberate. When Congress was debating the Sherman Antitrust Act in 1890, there's language there about any conspiracy or contract in restraint of trade. And one of the senators got up there and said, well, I'm all for being against monopolies, but what does this language mean? To which the sponsor of the bill said, I haven't the foggiest idea, but the Supreme Court can figure it out. So there are clearly many instances in which Congress is just being sloppy and actually relies on the court to come up with an interpretation. Another thing is they're being politically cagey, because if the law is struck down, then it's the court and not Congress that has done it. Some justices are willing to look at statements made in the House or Senate to help determine congressional intent. Others, such as Scalia, believe that such documents are irrelevant and that the only thing that matters is the wording of the statute itself. Now, statutory interpretation that does not involve constitutionality can be remedied by Congress revising the statute to make it clearer, or to say to the courts, this is not what we meant, and reenacting the statute with more precise wording. It should be noted that both a majority opinion as well as a dissent can lead to congressional revision. Two examples may suffice where a dissenter called upon Congress to reverse a majority opinion. In 1845, the court ruled on a statute changing the way that customs officers reported and submitted collected monies. The majority held that the wording of the new law abolished the importer's traditional common law remedy to sue if a mistake had been made. In his dissent, Justice Joseph Story declared that he believed the majority had misinterpreted the statute and suggested that Congress correct this mistake. Congress responded with alacrity, making it plain that it had never been its intention to do away with the remedy. More recently, the court ruled that the Equal Pay Act required an employee who believed she was being discriminated against because of gender to file a complaint within 180 days of the violation. Now, the Equal Employment Opportunity Commission had interpreted this provision to mean within 180 days of learning about that discrimination. Lilly Ledbetter had worked for many years at Goodyear before learning about the discrepancy in pay that affected her and other women employees. The majority decision effectively barred nearly all women from suing, since few, if any, would have known within 6 months that her pay was less than that of a man in a similar job. Justice Ruth Bader Ginsburg dissenting for herself and 3 other justices, not only attacked the majority for its crabbed holding, but also called upon Congress to modify the law and make it clear that the 180-day clock ran from the time one learned about the inequity. Before the day was over, Senator Hillary Rodham Clinton had announced that she would submit such a bill, and it soon became obvious that a majority in both houses of Congress would support it. Business lobbies inundated the White House with protests, and George W. Bush declared that if Congress passed such a bill, he would veto it. When Barack Obama became president, he immediately invited Congress to pass what he termed the Lilly Ledbetter Fair Pay Law and promised he would sign it. Congress reacted quickly, and Obama signed the bill as one of his first acts as president on January 29, 2009. The court also interacts with the chief executive. In some cases, it is really more a question of whether the law he is executing is in fact constitutional. Although the president may have proposed the law in the first place, the constitutional question will be whether Congress has the power, and the statutory query will be whether Congress meant for the president to act as he did. When the president or one of his cabinet members purports to act under the powers granted in Article 2, then questions deal solely with presidential power and authority. In any case involving the president or Congress, the court nearly always repeats the mantra that deference is due to the judgments of the coordinate branches of government. Despite that, the court has had no problem telling the president that he can't do certain things. One of the most famous cases involved Harry Truman in the steel seizure case of 1952. The threat of a strike by the United Steelworkers led Truman to conclude that a strike would jeopardize steel production in the middle of the Korean War. He believed he had the same power as Franklin Roosevelt had exercised during World War II, and directed Secretary of Commerce Charles Sawyer to seize and operate most of the nation's steel mills. Truman had no statutory authority to do this, and claimed he was acting under the executive authority of the president. Congress, however, had enacted the Taft-Hartley Act in 1946 that included procedures by which the government could secure an 80-day cooling-off period to postpone any strike that might adversely affect the public interest. Truman, however, had no desire to utilize that law, which he had vetoed and which Congress had passed over his veto. In the ensuing case, the court voted 6-3 that Truman had exceeded his authority, and they had a congressionally sanctioned method that provided him with a tool with which to handle the matter. More recently, one can see a dialogue between the court and President George W. Bush over the legal process due to detainees held at Guantanamo Naval Base in Cuba. After the beginning of the wars in Afghanistan and Iraq, the Army captured prisoners, some of whom the Bush administration labeled enemy combatants. It decided that these men would not be treated as prisoners of war, but held incommunicado and without redress to American courts. Cases attacking this policy began almost immediately, with the majority of the lower courts, as well as the Supreme Court, ruling that the administration had exceeded its authority under the war powers granted to the president in Article 2. The court could not have been more explicit than in Hamdi v. Rumsfeld, the case of an American citizen captured with the Taliban in Afghanistan. Quote, "We have long since made clear that a state of war is not a blank check when it comes to the rights of the nation's citizens," wrote Sandra Day O'Connor. Hamdi unquestionably had the right of access to a lawyer and from there to a judicial inquiry. Although Justice Scalia, joined in a rare pairing with Justice Stevens, agreed with the reasoning in O'Connor's opinion, they went even further in dressing down the administration. Reading from his partial dissent, Scalia said the Constitution offered only one way to achieve the administration's goal, and that was for Congress to suspend habeas corpus, a step that has not been taken in the contiguous states since the Civil War and Reconstruction. If civil rights are to be curtailed during wartime, Scalia declared in dissent, it must be done openly and democratically as the Constitution requires. There were several cases that followed, and in each and every one, the court told the president he had gone too far. In these cases, we can see the justices, both the majority and the dissenters, reaching out beyond the courtroom to talk to the president, to Congress, and to the people. Both Justice Kennedy, speaking for the majority in Boumediene v. Bush, as well as Justice Scalia in dissent, were trying to teach a civics lesson. Around this time, Justice Kennedy spoke to a group at the court in which he said that he considered education to be one of the most important tasks of a justice. Decisions and the reasons behind them had to be made clear not just to lawyers, but to the public as well. When the decision came down on June 12, 2008, Kennedy took the unusual step of orally delivering much of his opinion, which included a lengthy history of habeas corpus. Scalia also read aloud from his bitter dissent and termed the majority opinion devastating. In a democracy, there are or should be many participants in a conversation on public policy. The court, the president, and the Congress all have voices that are clearly heard. But there are others for whom the constitutional dialogue is important. One group consists of judges on state and lower federal courts. For them, the Supreme Court's constitutional rulings are supposed to provide guidance, and in most cases they do. When, however, there is a convincing dissent, these jurists may try to distinguish the facts of a case so that they can follow the dissent rather than the majority. The dialogue with the legal academy may not generate much public attention, but it is of concern to jurists and to law professors, especially since many judges are former law professors. Louis Brandeis became the first justice to cite a law review article in a Supreme Court opinion. He encouraged law reviews to analyze and criticize Supreme Court decisions because through such examinations, mistakes could be made clear. Today, of course, citing law articles is a common practice, and in some cases, one has what might be seen as dueling sources between the majority and dissenting opinions. Chief Justice William Howard Taft, who taught at the Yale Law School prior to his appointment, accused Harlan Fiske Stone, the former dean of the Columbia Law School, of, quote, hungering for the applause of the law school professors. Supreme Court cases are, of course, at the heart of most law school courses, and in the Socratic method employed in most schools, students and teachers engage in a rigorous analysis of cases, both the majority and dissenting opinions. A dissenter may hope, even if she will never know, that her argument won over a young law student who will later utilize that reasoning, perhaps as a judge. Trying to gauge the impact of court decisions and dissenting opinions on the public is difficult to do in any quantitative manner. But as historians, we can see that certain cases at particular times in our history have had an impact far greater than that of the litigants involved. While the 1857 Dred Scott decision did not trigger the Civil War, it certainly aroused a storm of public criticism that helped inflame passion over the next few years. The dissenting opinion of Justice Benjamin Curtis was reprinted and received wide circulation, and its arguments can be found in the Lincoln-Douglas debate and in the 1860 presidential campaign. In more recent times, the emotions triggered by Roe v. Wade in 1973 regarding abortion has continued to excite passions both in the courts and among the public for 4 decades. The appeal to the public is certainly behind the death penalty dissents of Thurgood Marshall, William Brennan, and Harry Blackmun. Marshall and Brennan dissented in almost every capital punishment case during their tenure, reiterating their belief that the death penalty violated the Eighth Amendment ban on cruel or unusual punishment. Harry Blackmun came later to this position after grappling with the issue for 2 decades. In doing so, they went against 2 centuries of precedent, as well against the support of capital punishment by a majority of Americans. During the long time that these 3 justices served on the court, they knew they would be in a minority. They hoped their dissents would convince the public and appeal to the intelligence of a future day. Whether these dissents ultimately become accepted as the law is impossible to tell. There is no question, however, that they are part of the dialogue and that groups opposing capital punishment have seized upon these opinions to bolster their own case for abolition. Barry Friedman has convincingly argued that much of the Supreme Court's prestige and influence has resulted because they do indeed pay attention to public sentiment. Long ago, Mr. Dooley said that the court follows the election returns, and there is no question that the judges, who are for the most part quite politically sophisticated, are aware of the limits of public tolerance. When the court has gone too far, as in Dred Scott or Roe or in opposing New Deal measures, there's been a public reaction. One can see the court taking a firm stand in the case establishing an individual's right to die, but treading carefully in the assisted suicide cases, preferring to leave the matter to the political process. In 1986, when the court ruled that homosexuals had no right to engage in consensual sex, the gay community and civil liberties groups praised the dissent of Justice Blackmun. But for the most part, the public did not find the decision unwelcome. Over the next quarter century, however, public acceptance of gays and lesbians increased markedly, especially among younger adults. So when a split court in 2000 upheld the Boy Scouts of America policy on excluding gays, the general reaction was far more critical, and this time the dissent found fairly wide support. In 2003, the court reversed itself and held that gays did have a right of privacy that the state could not impair. This time the opinion stirred little controversy, and the dissent was seen as reactionary. Then in 2013, with public opinion polls showing a majority of Americans supporting the rights of gays to marry, the court struck down DOMA over the impassioned, one might say, rabid dissent of Antonin Scalia. I am not implying that the court was the most important player in all these debates. Rather, policymaking in a democracy involves multiple voices, and it is the dialogue between and among the participants that is critical. Dissent has been an important element within the court from its beginnings in the late 18th century. At the same time, the important dissents have involved the court with other political actors such as Congress, the President, and the public. Not all dissents have great impact, and the vast majority of them are soon and rightly forgotten. The majority decided correctly, public opinion supported the result, Congress or the President accepted the results, or the cases themselves proved not to have lasting importance. But some dissents matter greatly. They have shaped the constitutional dialogue. They have successfully appealed to the intelligence of a future day. Thank you. Yeah, sure. Why not? Just like a classroom. Anybody got a question? I always worry when nobody raises their hands. It means that either I've been really, really bad or so convincing that everybody's on my side. I prefer the latter, but a question, okay.
You began your talk with a brief overview of how some other societies, highest courts, reach their decisions. Do any sort of use a classical consensus method in which the decision is basically we cannot reach consensus, or yes, we do have?
No, nearly all of them reach a thing, but I mean, there's some places where the law actually says there can't be a dissent. So let us assume that there are 7 members of a court, and 4 of them reach an agreement. You never hear from the other 3. It is announced as the decision of the court with no count. So you don't know if the vote was 4-3, 5-2, 6-1, or unanimous. And this has been the tradition, and it's not that these countries don't value individual rights, it's just a different custom they have for what the courts decide. Because we inherited the seriatim tradition from Great Britain, we have always had a moray that there could be a separate opinion. Yes?
Yeah. So, Mel, you make a good case with some of your examples that prior dissents have been prescient, but I'm not sure that you persuaded me that they're also influential, because how are we to know, particularly since dissents are rarely cited when the court changes course, the new justice just file on ahead, that really dissents are just placeholders and that what's making the decision are future appointments. It's not the court's it's not the court being persuaded by the dissents. It's that eventually just new justices come in and they happen to agree with the dissent.
Well, the reason they happen to agree with the dissent is because the dissent has been percolating in the legal world for a long time. For instance, take Betts v. Brady. That's the case in which the court back in the early 40s held that states did not have to provide attorneys to people accused of crimes, except in special circumstances, if the person was mentally impaired or if there was a complex matter of law. Over the next 20 years, whenever a legal representation case came to the High Court, they always found a, quote, special circumstance, until we get Gideon versus Wainwright, in which the court completely overturns it. Now, there were still a lot of judges on there, and what's interesting is that Hugo Black, who wrote the majority opinion, went to see Felix Frankfurter afterwards. And he said to him, Felix, you know, we overturned Betts v. Brady, and Felix said, it's about time, I would have voted for that too. So, I mean, the legal mentality changes how people view the First Amendment right of free speech. You can see, you know, if you follow free speech cases, starting back with Schenck and Abrams in 1919 down to Brandenburg in 1969, you can see the Holmes dissent, the Brandeis concurrences, cited and cited by different people until finally you get to 1969. So yes, of course, changes are, but where are these people coming from? They're coming out of law schools where the dissents have been given greater emphasis by law professors who say, I can remember when I was in law school in the 1980s, I don't know how many cases where the professor said, the majority opinion here is out and out stupid. No, and then would go to the dissenting opinion to show that it was right. And lo and behold, eventually, you know, people who came out of these law schools who had heard how the dissenting opinions were, quote, right, become lawyers, they become judges, they move on up. So that's how it percolates. I mean, in the book, I think I talk a little bit more about this. It's not just that the dissenter says, I dissent and this is why, and then 20 years hence something happens. They have to make a very good argument. You can follow Brandeis's opinion on privacy, and you can go case by case by case as to where, until it finally achieves something. And it's not just that there was a change on the court, the whole mentality within the legal universe as well as the public had changed. Yes?
Well, continuing that same question from the professor, and perhaps a hybrid sort of question about it, perhaps Mr. Dooley was correct. It's not a function of the compelling nature of the legal analysis, but it's more a function of the jurists being a moderating influence on whatever the public sentiment might be over the course of time as it changes.
Well, the court has been willing to go against public sentiment, certainly against Southern public sentiment in the discrimination cases of the 1950s and 60s. The court, one of the problems on the court is that there's no one on the court right now who is ever an elected official. I think Anthony was pointing out that when Sandra Day O'Connor resigned, she was the last, it was the first time ever in the nation's history that we had no elected officials on the High Court. And I think this is a problem, in that I would like to see a little more political sophistication and awareness among the judges than we have. But according to Friedman and others, the court should be, remember, the court doesn't have any battalions. Now, like the Pope, they have no regiments there. They have a marshal. And so when they rule, for instance, that Richard Nixon had to turn over those tapes, the only way they could enforce that was through public support of their thing. I mean, the marshal at that time was, what, 60-some years old? You can just sort of see him tottering over to the White House, and say, I'm here to get the tapes from the president, and the Secret Service says you're not coming anybody near this guy. So there has to be this respect for the court, and the court's very much aware of that. That's why they're so careful. They got out in front in Roe v. Wade. I'm not saying the opinion was wrong, but I think, I sort of agree with Justice Ginsburg, it came before it had to come. And you can see that when they got to the assisted suicide cases, it said, had everything but a label on top of the opinion saying, don't do Roe again. Don't get out in front of public opinion on this. Let's leave it to the states, et cetera. And that's why you get these 5 concurrences, essentially telling the states, you know, we're not averse to you moving forward, but we also are not going to allow you to move back and tighten up end-of-life choices. So I think, you know, the political part is a very important, what should we call it, subset of the dialogue. The court has to be aware of what's going on out there. And of course, I would argue that although there are no Tea Party members on the court, at least as far as we know, the court very much reflects the political divisions we have in this country right now. Any other questions? If not, I thank you again. And we're done.